judges you have in the particular case. The Brighton Declaration is going to put these principles into the Convention. The Brighton Declaration is quite clear about the changes to the admissibility criteria we're going to make, which would, Sir Nicolas, I've no doubt, would argue, more or less reflect where he wants to go anyway. But it will become the norm, as opposed to what sometimes happens. And if it became the norm and was done properly, we would in fact get rid of our arrears, and we'd have fewer cases where the court was just acting as a fourth level of appeal from a case that's already been quite properly and adequately considered by the national courts of the country concerned.
But may I add here that it is not sufficient for any member country to say or to claim that they have dealt with a case based on the standards of the convention, because if that would be the case, then I know many customers to the court that would say, oh, we have dealt with this case on the basis of convention, so please keep your hands away. It is for the court to decide whether an application has been dealt with properly on the basis of the convention. So the court has a final word, and that has been reconfirmed by all the contracting parties, and the right of application has been reconfirmed by all the contracting parties. That is very important with this. But it is also very important that the declaration says that one should introduce the principle of subsidiarity and the margin of appreciation into the preamble of the convention. These are principles that the court that has underpinned the court from the very beginning, but it is very good to get it into the preamble of the convention, of course.
And it will become the norm. I mean, I underline that's what the Convention's for. We try to actually maintain and improve standards of human rights across 47 states in the European Union. And the whole point of having the Convention is to reinforce our values, and the court is there to make sure they are maintained and to test it when they are questioned. And they have to have proper regard when national institutions have properly applied the Convention. All countries are equal in the Council of Europe, so take a random example. If the courts in Ukraine or the national parliament in Ukraine insists that its judgments are compliant with the obligations under the Convention, then, you know, my first instinct, of course, with colleagues would be to accept what they say. But if there's an individual application which starts alleging that there are serious shortcomings in the judgments in Ukraine, we don't say that the Ukrainian government's allowed to say, we have decided that, and in our opinion, this should not be going to the Court on Human Rights. I personally would welcome the Court of Human Rights to give rulings in cases of that kind, and I think in order to maintain things, we should accept that all 47 member states are under the same obligations in that respect, to observe the Convention and to respect the proper jurisdiction of the court. Second row, sorry, first two.
Frances Gibb from The Times. Can you comment, please, on the fiasco over the deadline for the appeal by Abu Qatada, and particularly on the view that seems to be prominent amongst legal experts that the government actually got it wrong?
I imagine whilst I've been in this conference, a very great deal of comment has been flying around in the wider world about that, so I proceed with even more than my usual caution, Francis. I mean, I'm not accustomed to procedural disputes or issues arising at the early stages of litigation of all kinds, and obviously a procedural issue has now arisen between the two parties about this guideline. I'm quite sure, personally, I have every confidence the Home Office lawyers will conduct their argument properly on behalf of the government, and that the whole thing will be resolved by a panel of judges. I don't think it's much use my commenting on it. I could not claim either to have sufficient expertise personally in the procedural rules of the Court of Human Rights. That's not my role at all, nor do I know enough about the argument that's been raging in the course of the day, apparently, on this very important issue. Well, one thing we do know is that we always knew that resuming the process, starting as the Prime Secretary explained, starting this process of resuming the deportation action against Abu Kataba would certainly take months, because you're engaging on a fresh legal process in the light of the undertaking she's got from the Jordanian government on the evidence they're going to use in the retrial. But I doubt whether I could add anything that's very either authoritative or informative on the dispute that's now raging about what the time was when the right to appeal expired.
Thanks very much. David Grossman from the BBC Newsnight programme. Mr. Jaglin, can I ask you a question, please? What would you say to those people in Britain, some of whom are in Mr. Clarke's own political party, who express a lot of anger at the fact that a foreign court is preventing British courts deporting foreign nationals? And they say, and they are saying increasingly, that unless that system is streamlined and reformed significantly beyond where you've got to today, that Britain should consider withdrawing.
I would say that actually it is the court in Strasbourg that has paved the way for UK to deport this person under the rule of law. Because the ruling by the court indicated how this could be done, namely to obtain a guarantee from the government of Jordan, and then it could, this person could be deported, and this process has already been started. So I think it's very important to keep in mind that combating terrorism, which is, as I assess this is about, has to be done under the rule of law. Doing the opposite has not been very successful. And another matter here is that basic principles in the European Convention on Human Rights, which all member states have signed up to, is that you cannot expose anybody to death penalty, ill treatment, or misuse of evidence in a court. Here, there is no margin of appreciation. So, I mean, I'm coming from Norway. We have a similar case there. A man that is clearly a terrorist, he cannot be deported to Iraq because he would immediately get the death penalty. This is the basic principle in European humanity, that we don't expose people to death penalty, ill treatment, or evidences in the court that is under threat. So the court in Strasbourg has paved the way for deporting this person under the rule of law. That is very important for UK, I think.
When we were in opposition, the Conservative Party was very supportive of the rule of law and very critical of the authoritarian government that we then had, and we have improved matters since we've got in office. We didn't need prompting to do that. We only lose about 2 out of 100 applications at the most. It's more like 1 in 100 of the applications made against the United Kingdom to the court. It's always very frustrating when you lose a case, I understand that, and in the important ones, as we're demonstrating, you can appeal, you can adjust the problem and go again to get the end you want if you've got to deport somebody who's dangerous. We also win cases. They never get reported. We win very valuable cases. We won, for example, on holding DNA that had been given by people who'd never been charged. We won, we won, Britain didn't, but the Conservative point of view won on the abuse of stop and search powers, and the present government is implementing the consequences of those judgments. So I would invite some of my colleagues to get very excited, as I've known a lot of disappointed litigants to do, about losing one case, to take a slightly more balanced and relaxed view about the overall impact of the Convention and the Court. I think friends of Britain in the world would think it very, very peculiar if the United Kingdom decided to join Belarus in being the only 2 European countries leaving the Convention on Human Rights.
William Horsley, Association of European Journalists. I'd like to ask you, you speak about the appalling backlog. The appalling backlog is there because many citizens in European countries can't get justice in their own countries. So I'd like to ask you what this declaration is going to do for improving the national court's administration of justice. The judges in Strasbourg speak about the fact that their general measures, which are supposed to be applied throughout, are being ignored. The Council of Ministers very recently came up with a decision on impunity, because it is so widespread inside the Council of Europe. And they point to the fact that these abuses are carried out very largely by employees, state employees, abuses against their own citizens. What will your declaration do to improve the administration of justice inside the member states?
Well, it's not just my view. I think the Germans are particularly strongly of the view, with many other countries supporting both of us, that quite a lot of the cases that are brought are quite trivial. I'm not sure about the one that's been quoted in the British press the last day or two about the man claiming a few euros compensation for uncomfortable bus seats. I quote it with caution. It may turn out to be a somewhat decorated version of what the actual facts were, but there are undoubtedly very, very trivial cases that are brought, and it stops the court being as effective as it otherwise would be in dealing promptly with the more serious cases. And as Mr. Jagland was saying a moment ago, when they get round to looking at them, about 90% of these applications are not really admissible under the Convention. And if you don't do something about getting that queue of cases out of the way, you have years and years of incarceration for people before you can hear more serious allegations. But the last, I'll take the ones who've now got their hands up, the last. So there's 4 people here. You've had a question already, and 1 there. So let's take it. Sir, holding the microphone.
Martin Beckford from the Daily Telegraph. David Cameron went to Strasbourg in January and made some very tough words. And he's not come here today, and the agreement you got is very technical. And even the President of the Court has said it's not going to make any difference. Won't this leave you without any big changes, dash the expectations of Tory backbenchers, and so make the problem with the court worse amongst the public and your own party?
I fear you've not reminded yourself of what David set out for us all to do. He never was going to come to Brighton today. We've got me and the Attorney General here. You know, it isn't normal for the... I don't think anybody... I've never been to one of these Council of Europe things where the Prime Minister has turned up with 2 of his ministers. For the convention, he would have been very welcome had he come. But I've spoken to the Prime Minister about this. We've discussed it at Cabinet. We have achieved what he set out as our aims when he spoke, and it isn't all that technical. I've got it in front of me. I think you probably got the briefing pointing out the 3 things in particular that he set out as our goals when he spoke and launched our chairmanship. And throughout all the negotiations which I've engaged in, which William Hague has engaged in, which Dominic Grieve has engaged in, together with our junior ministers, David Liddington, Jonathan Ginogly, the government's put an enormous amount of effort into getting 47 member states to come together and agree a declaration which faithfully reflects the goals which the Prime Minister set out. And as I've already said, it now remains, of course, for the court to put into practice what we have established, which will speed up the momentum of getting rid of the delays, the excessive number of trivial cases, and actually only dealing with the serious cases, and only dealing with those where there's an allegation that there might be some substantial breach of obligations, and not just hearing fresh appeals where the national courts have already quite properly applied the obligations of the Convention. So, you know, I understand your critical and probing question, but actually the general feeling at the Cabinet meeting we had earlier this week was we were really rather surprised that we'd achieved such considerable success. And that's because, apart from anything else, I've always thought that trying to get 47 governments of 47 individual countries to agree on, dare I risk today saying what day of the week it is quite difficult. So to get 47 to agree on the text of a declaration which makes the changes, which this one does, is, I think, quite a substantial achievement. So I'm going to take the last ones. There was there, and there, I think.
Jack Doyle from the Daily Mail. Is there any significance to the fact that the measures on the margin of appreciation and subsidiarity are in the preamble to the Convention rather than the Convention itself? Is that not a significant setback? as some are claiming?
I've no doubt you could find somebody somewhere who thinks it's played with great theological significance. I mean, it was a move made in negotiations, but they're all the negotiations I've ever known. You don't start up where you intend to finish, and I personally can't see it makes the slightest practical consequence what page of the thing it appears on. So I don't think there is. If there is any deep hidden significance in that, it's eluded me, I must say. And I am a qualified lawyer, I hasten to add, who once used to have a serious practice.
Hi, Oliver Bullough. I think you rather dodged quite a good question from over there earlier about the backlog of cases from Eastern Europe. These aren't trivial cases. There are hundreds of right-to-life cases. These, unless countries such as Russia reform their legal system, these will keep coming anyway. So how will this help force through reforms to legal systems inside member states?
Well, but there are more cases against some countries than there are against others, and there are bigger arrears in some places than there are against others. It is the cumulative mass, which means that almost nobody's cases are heard in the time in which they should be. Everything, it takes years before it gets on, and all of them contain some trivial, some serious. The sooner we have a process which, quite blindly, as it were, just gets rid of the ones that we should get rid of and only deals with the serious ones, then the sooner you can deal with the serious breaches of the Convention wherever they occur. What you can't do is start saying we're going to get rid of all the cases against one country but not against another. And the Secretary-General's already underlined what I haven't underlined enough myself. Everybody agrees, everybody in that conference agrees that the obligation on national governments to oblige by the obligations under the Convention underlines everything we're talking about. Things will be greatly improved. All 47 member states were better at honouring their obligations. So.
Owen Bohart from The Guardian. I was left slightly confused by the disparity between Sir Nicolas Bratza's mention of the fact that Britain's attempt to change the admissibility criteria had been deferred and the fact that in your statement you say it's been tightened up. Can you explain the disparity? And is that because you've made some progress, but not as much as you'd like?
Well, we have changed the admissibility criteria, and it's in the declaration, and we've agreed. We've now got quite a number of points, actually, which have got to go through the technical process of being implemented by the end of next year. I think the difference between Nicolas Bratza and myself is obviously he's a bit worried about everybody starting enthusiastically reforming his court, so he's rather implying, well, all this would have happened anyway. I have to say, I regret to say, I'm not wholly convinced of that. It might have taken place anyway, but it would have taken many, many years. I think he doesn't seem to be arguing with any of the things we're doing. I think actually an extremely good thing that we will now have made it the norm in the way the court operates, and we'll have made it the norm rather more quickly than would have been the case if the British chairmanship hadn't taken it all up. And again, we have a more objective judge of this slight nuance of opinion between the British judge and the British minister. If Mr. Jagland wishes to comment, or you're staying neutral, though, you thought.
No, but it is a matter of fact that in Protocol 14, there is an admissibility criteria, which, when the Russian Federation ratified this protocol, entered into force. That helped the court a lot. You can prove it. And now we are amending this admissibility criteria even further, and it will help the court further. That's clear.
In my negotiations, one of the arguments that appears on Protocol 14 was there were member states who were my ministers of justice inclined to say, well, let's see how Protocol 14 works. Now, my view was that this meant let's wait another 3 or 4 years and see whether the arrears have got down from 150,000 to 80,000. That was not good enough, and I think we've succeeded in persuading people. Spirit of compromise, some would say. We've done no harm by strengthening it. I think we've done quite a lot of good, because I think we'll get the numbers down much more quickly and get down to the core job more effectively because of the Brighton Declaration.
Tisha Kessler for the Dutch newspaper NRC. Mr. Jagland, have you talked about sanctions for countries that send repetitive cases to the court? And second of all, how do you deal with the political backlash and social backlash, especially here in the UK?
Well, it's to the second, the last part of your question, it's not up to me to deal with politics in UK, but I think all of us should do more in order to convey why we have this convention, what it is about. It is about securing the rights of everybody, and very often it is about securing the rights of minorities. And as the Minister of Justice said, if, for instance, UK leaves the convention, what kind of signal would that be to people that are really struggling for basic rights back home in Europe and also worldwide? I mean, here in Europe, we have, this is the only real implementation of the Universal Declaration of Human Rights, by establishing the monitoring bodies, and on top of that, the court, which enables 800 million people to petition to this court. What kind of signal would it be if UK left this convention system to the world? And I mean, if Europe started to dismantle what we did after the war and because of the war, I mean, this has to be, we have to do everything we can to convey what we lose if Europe starts to dismantle this human rights protection system. What was the first part of the...
have you talked about sanctions?
Yes, sanctions. Well, we don't have, well, the sanctions is, we don't have sanctions if you think that we can impose economic sanctions, that kind of things, but the Committee of Ministers, where 47 governments are represented, have the responsibility to execute the judgments. And actually, all the member states are doing that, some slowly, but they are executing the judgments. Of course, the ultimate sanction is that they are suspended from the organization, but that has been used only once, namely when we got the junta in Greece. And also Turkey was, for a short period of time, suspended. But we are not talking about that now.
Okay, ladies and gentlemen, thank you very much for attending our press conference. I hope you've enjoyed your day at Brighton, sort of almost a nostalgic reminder of what party conferences used to be like. Thank you.
My colleague was talking downstairs in the phone, so...